Trigger warning. This episode contains discussion of sexual abuse, trafficking, and the traumatic accounts of survivors. Viewer discretion is advised. Do you solemnly swear? The words of the courtroom oath are short, blunt, absolute. Under penalty of perjury, people tell a judge what they say is true. Those sworn statements are the thread that runs through the newly unsealed court files tied to Jeffrey Epstein and Ghislaine Maxwell, documents that, when opened, read like a map of wealth and access, stitched together with allegations of sex trafficking, recruitment, and exploitation. The shock is not only in the acts described. It's in the way money, private planes, sealed compartments of privilege, and elite social networks appear to have insulated a pattern of abuse for decades. For anyone encountering these files now, the same two reactions often arrive together: anger at what survivors say happened to them, and incredulity at how someone with Epstein's resources could allegedly operate with so little immediate consequence. The court papers do not answer every question. They do, however, reveal a set of relationships, logs, and sworn claims that force a stark question: how does wealth bend the arc of accountability? The human stories in the filings are what make the paper trail unbearable and impossible to ignore. Below are 3 profiles drawn from the publicly available testimony and reporting, framed as claimed under oath, and described in non-graphic terms to keep focus where it belongs: the harm, the consequences, and the long fight for recognition. Virginia Giuffre. According to sworn statements filed in court, Virginia Giuffre says she was recruited as a teenager and was trafficked by Jeffrey Epstein and Ghislaine Maxwell. In multiple civil filings, she has described being moved between residences, introduced to people in elite circles, and coerced into sex with men she later named in her complaints. Those names, and the distinction between naming someone and proving criminal conduct, are central to how these documents have rewritten public conversation. Giuffre's testimony became the basis for a defamation suit against Ghislaine Maxwell. In the course of that litigation, reams of material were filed under oath. That process is one reason so many pages previously sealed are now in the public record. Courtney Wild. Court filings identify Courtney Wild as another survivor who gave detailed statements about her interactions with Epstein's circle. Publicly, she has described how the abuse began when she was a teenager, and how the after-effects, from mental health struggles to disrupted lives, continued long past the events themselves. Her sworn declaration, like others, emphasizes the human cost: damaged trust, lost opportunities, and a lifetime of dealing with consequences that no legal settlement could erase. Maria and Annie Farmer. Maria Farmer has long been identified in reporting as an early whistleblower who raised concerns in the mid-1990s about Epstein's behavior and the conduct she witnessed. According to filings and interviews that are part of the public record, Farmer reported suspicious behavior to art world contacts and to law enforcement in the 1990s, a claim that, at the time, did not spur a federal investigation. Her sister, Annie Farmer, has also given sworn statements asserting she was assaulted by Epstein in the mid-1990s. The Farmer's early complaints and the apparent failure to galvanize sustained law enforcement action are recurring threads across the documents and the reporting that followed. These are not anecdotes to be punctuated and set aside. These are sworn narratives from people who describe lives derailed. The documents place victims' words alongside flight manifests, email exchanges, and financial ledgers. That combination is what makes the newly released files both gruesomely intimate and scorchingly informative. Page after page connects people, places, and dates, sometimes in ways that create clear lines of inquiry, sometimes in ways that raise more questions than answers. If this subject matters to you, and you want the full breakdown of the court files and the timeline we're reconstructing, subscribe. We've linked the primary documents and source reporting so you can see what's public for yourself. How did this all come to light again and again over decades? The short answer is, through a patchwork of survivor testimony, persistent investigative reporting, uneven law enforcement responses, and finally, civil litigation that forced records into open court. The longer answer traces back to the 1990s, when a handful of people raised alarms that, at the time, attracted attention, but not the kind of full federal scrutiny people would later demand. The investigative trail begins with early complaints, and with journalists who kept returning to a question that, to many, seemed unanswerable. How could someone living in plain sight maintain secrecy and access to so many powerful people? Maria Farmer's accounts from the mid-1990s are among the earliest public complaints in the record. She reported behavior to art institutions and law enforcement. She alleges she faced resistance and disbelief. Years later, other survivors came forward, and journalists pieced parts of the story together. Vicky Ward's early reporting introduced Epstein to a broader public audience, but as reporters later noted, some editions of early magazine pieces softened details about the women involved, and the broader narrative about trafficking did not yet cohere in mainstream coverage. A key, controversial turning point in the story was the 2006 non-prosecution agreement reached between federal prosecutors and Epstein's team. That deal, which has been widely criticized by subsequent prosecutors and Congress, resolved federal allegations through a Florida plea arrangement. Its effect, as described in congressional oversight and reporting, was to limit the scope of federal charges and to seal many aspects of the investigation. Victims and their advocates argued then, and have argued since, that the agreement allowed Epstein to avoid the full weight of federal prosecution, and that many names and leads were never pursued aggressively by the authorities who had jurisdiction. The legal and political fallout from that deal has become part of the story itself. A prosecutor who later served in the federal government drew public scrutiny for his role in negotiating the agreement. Civil litigations and public pressure pushed back against secrecy, but years had passed. It was not until 2019, when Epstein was arrested on new federal charges, that the simmering public outrage returned to a boil. His arrest brought the focus back to the question of who else might be implicated, and whether the earlier protective structures had concealed a broader network. Epstein's death in custody in 2019 complicated the arc of criminal accountability. He did not stand trial on the federal charges that had brought him back into the public eye. His death meant that many victims' hopes for a public criminal adjudication of his conduct died with him, and it also raised questions about what records would remain sealed and what would come to light through civil litigation and subsequent prosecutions. Ghislaine Maxwell's arrest and prosecution, culminating in her conviction and later sentencing, added another layer. Her case created an opportunity for victims to testify in a public forum and for courts to consider evidence under oath. Civil litigation became the vehicle for additional disclosure. A prominent defamation suit filed by Virginia Giuffre against Ghislaine Maxwell produced voluminous filings. Many documents were redacted and sealed during the litigation, but through court fights and a judge's rulings, numerous pages were ultimately unsealed and released. Those documents, now viewed as the unsealed court files, contained dozens of sworn statements, flight logs, contact lists, and other materials that had until recently been inaccessible. What the documents themselves contain varies in form and in legal force. There are sworn statements, written declarations submitted under penalty of perjury describing alleged conduct, locations, and names. Those statements are legally weighty as allegations, but they are not the same as a criminal conviction or an adjudication of guilt. There are flight logs, lists that show passengers on Epstein's private aircraft. Flight logs can place someone on a plane at a given time, but they do not by themselves prove participation in criminal acts. There are photographs and references to images, emails and text message fragments, and, in some filings, references to alleged recordings or videos that survivors and others have said were made. And there are redacted passages, pages with names blacked out, that suggest content the court or parties considered sensitive. Across these forms of evidence, the newly unsealed files make a few things clear. The network was vast. Epstein had unusual access to private spaces, and many people who crossed paths with him had institutional power, from business to politics. But the files also underscore how careful any public accounting must be. The documents name more than 150 people in various contexts, some as witnesses, some as social acquaintances, some as people who allegedly participated in misconduct, and others merely as names that appeared in mailing lists or social calendars. The legal distinction between named and accused appears throughout the filings and has to guide how the public receives this material. What is striking is not just the list of names, but the mechanisms the files reveal. Invitations to private properties, travel on private planes, contact lists that mix the famous and the anonymous, and a pattern of recruitment the survivors describe in remarkably similar terms. They describe grooming, financial incentives, and a rotation of locations, secluded mansions, private islands, and foreign residences that created both physical and social isolation. Ghislaine Maxwell, according to numerous filings, is presented as a pivotal figure in that logistics chain, a person alleged by many witnesses to have recruited and coordinated encounters. Maxwell has been convicted of related charges. Her conviction is a significant public adjudication that anchors some of the civil claims. At the same time, the documents remind us of a basic principle of the law. Allegation is not adjudication. Some high-profile names have been thrust into headlines simply because they appear in these voluminous files. Bill Clinton, for instance, is listed in flight logs as having flown on Epstein's plane on multiple occasions. His representatives have said these were for work related to the Clinton Foundation and have denied any wrongdoing. Prince Andrew has been named in sworn statements by a survivor who says she was forced to have sex with him. The prince has denied the allegation. Richard Branson has been listed in certain contexts in the filings. He has denied participation in any misconduct. Other names appear as social acquaintances or as people who visited Epstein's properties. The unsealed files include many instances where names are tied to an event or a plane manifest without any corroborating material that proves criminal actions. The public instinct to connect every dot is understandable. The legal and ethical obligation is to distinguish between what a document shows and what it proves. Another recurring element in the files is the claim that Epstein used the materials he collected, photographs, intimate recordings, or other forms of evidence, as leverage. Some sworn statements use the phrase, "there are videos that exist." Those words, when they appear in legal filings, have a different weight than the same phrase said in a gossip column. They are an assertion made under oath. That makes them newsworthy and chilling. If recordings existed, and if they fell into the wrong hands or were used strategically, they would represent a form of blackmail that could explain the apparent ability of Epstein to forestall consequences. But even here, the caveats are crucial. While some survivors assert the existence of recordings, and while investigators reportedly sought such material, public authorities have not produced verified, authenticated video files in the way that would conclusively resolve that question for the public record. Even the most forensic parts of the files, flight logs, ledger entries, and receipts, require careful interpretation. A name on a manifest could mean many things: a social call, an unconnected business trip, or potentially involvement in criminal conduct. A photograph can show proximity, but not consent. A message pad can show a contact, but not an agreement to commit a crime. The newly unsealed files are valuable because they assemble these disparate data points under oath. They are not, by themselves, a criminal indictment of everyone who is named. The interplay of secrecy and access is evident in the physical architecture described throughout the documents. Epstein owned or had control over multiple properties: a Manhattan townhouse, a Palm Beach home, a New Mexico ranch, and an island in the Caribbean that is frequently cited in reporting. Those properties, the filings suggest, functioned as nodes, places where a curated circle of guests could gather, be entertained, and, according to survivors, be manipulated. Private planes connected those nodes to international destinations. The logistics described by several survivors and supported in places by travel records and receipts indicate the reach of the operation. One consequence of that infrastructure was the normalization of access. Wealthy guests were invited into a world where private jets and closed-door homes created a protective fog. Rules of social deference, the orbit of patronage, the currency of philanthropy, the instinct not to embarrass the wealthy, all played roles in keeping scrutiny at bay. Institutions that might have examined conduct more stringently, certain law enforcement offices, some in the media, and parts of the society that defer to power, instead produced a pattern of partial reporting, delayed investigations, or confidential settlements. Critics point to episodes where journalists were discouraged from naming alleged abusers, or where editors were nervous about libel. Survivors and their advocates say that power and money repeatedly slowed down or muted accountability. That institutional failure is a key theme of the files. The 2006 non-prosecution agreement, the sparseness of early investigations, the way private settlements sealed records, all of these elements appear to have allowed a system of alleged abuse to become entrenched. And yet, the unsealing of documents has begun to strip away those protections, at least in public discourse. When civil filings, flight manifests, and sworn declarations enter the public domain, they become raw materials for investigative reporters, for prosecutors revisiting cold leads, and for the public trying to understand whether the wealthy play by the same rules. It is here the narrative forks toward two critical questions that frame the rest of the documents. First, who else, if anyone, should be investigated in light of the filings? And second, what can the records actually support in a court of law? The answer to the first is political and prosecutorial. The answer to the second is evidentiary and legal. The unsealed files fuel both inquiries. They act as both a furnace and a filter. They heat public attention, and they require careful sifting to see what endures under scrutiny. In the days after the unsealing, media organizations sifted through thousands of pages. Journalists with long memories matched new statements to older reports, looking for consistencies and contradictions. Some lines in the files felt almost bureaucratic: lists of phone numbers, entries in a ledger for massage, notes about plane departures. Others read like personal testimony, accounts of manipulation, isolation, coercion, and the long aftermath of trauma. That juxtaposition, the bureaucratic next to the human, is what gives the unsealed files their power and their difficulty. They demand both emotional engagement and forensic caution. There are several recurrent high-profile names that appear in the newly available material. Those appearances sparked headlines, social media furor, and renewed pressure on institutions to explain what they knew, when they knew it, and what they did about it. The documents contain references to public figures, some as passengers on flights, some as hosts or guests at properties, and some as names in address books or calendars. Each mention requires careful qualification. Some people named in the files deny any involvement with wrongdoing. Some have acknowledged social or charitable interactions but rejected allegations. Others have not been criminally charged. The presence of elite figures in the files, business leaders, politicians, aristocrats, is part of what makes these documents shocking in the way the title promises. The shock is not merely that rich people are allegedly involved. The shock is that wealth appears to have bought both proximity and, in some cases, apparent impunity. Power, as the files imply, can function as a form of protection. Quiet settlements, sealed documents, and institutional reticence all play into a broader picture in which allegations struggle to become prosecutions. But this is where the public must be careful. Naming and shaming by headline is not justice. The legal distinction between an allegation in a civil filing and a criminal conviction is foundational. For every high-profile name listed in these pages, the question is the same. What is the context? What corroborates it? And what does it actually prove? Our duty as investigators and as a public is to follow the documents without letting the celebrity of names substitute for the work of evidence. As the first tranche of documents was sifted, reporters asked technical questions that dig into how evidence functions. If a flight log lists a name, was that person traveling alone on the plane at a time when alleged wrongdoing occurred? If a ledger has a payment, to whom was it made, and was it for a legitimate service? If a sworn statement claims the existence of a video, who had access to it? And has any independent party verified it? The unsealed files provide the starting points for those questions, and the answers require cross-checking witness statements and, where available, corroborating digital or physical evidence. Beyond individual accountability, the files shift the conversation to institutional and cultural responsibility. How did banks, law firms, private schools, and philanthropic circles enable or ignore red flags? How did editors and producers in media outlets make choices that softened narratives or avoided naming alleged abusers? How did prosecutors and federal agencies weigh the evidence and decide where to allocate resources? Those questions are not answered in a single filing, but in the pattern the unsealed documents help reveal. There is also a moral question that persists quietly under every page. What does justice look like in a context where some perpetrators are dead, some victims have settled, and some institutional actors prefer confidentiality? For survivors, justice is rarely a single courtroom victory. It is recognition, accountability, and systemic change that reduces the likelihood of repetition. The unsealed files are a step toward recognition. Whether they lead to meaningful systemic change will depend on what the public, the press, and law enforcement do next. At the edge of these documents, and at the center of the public conversation, sits the question of leverage, of blackmail, of recordings, of stored materials that could be used to coerce. The filings include sworn assertions that recordings were made. They also include redactions and references that suggest investigators pursued leads about potentially compromising materials. But public authenticated proof of specific incriminating recordings has not been produced as a singular, dispositive artifact that resolves the question for the public. The presence of testimony claiming recordings is newsworthy and serious. It is not, however, the same as conclusive proof. What the newly unsealed files accomplish in the immediate term is to provide a shared evidentiary basis for public and legal scrutiny. They give journalists something to analyze, prosecutors something to review, and victims a record to carry into courtrooms or legislative hearings. They also raise the stakes for people named. Once the public sees your name in a flight log or in a ledger next to Epstein's, the reputational consequences can be immediate, even if the legal consequences are not yet present. So what happens next? That is the question that will shape the subsequent parts of this narrative. Will prosecutors reopen investigations with new vigor? Will elected officials demand oversight into the 2006 agreement and into institutional responses? Will victims find additional avenues for accountability? And will the public process the difference between being named and being proven culpable? These are not theoretical questions. They are practical choices that determine whether these records remain static evidence or become catalysts for action. In the coming segments, the documents themselves will be examined in greater detail. Specific flight entries will be cross-referenced, sworn statements will be analyzed line by line, and the legal implications of naming will be explored with experts. For now, the Unsealed files have done two things. They have confirmed the scale of alleged wrongdoing, as described by multiple survivors, and they have made unavoidable the uncomfortable reality that wealth can, in practice, create spaces where alleged abuse can persist. As I read through the newly unsealed pages, one pattern insisted itself. The closer you look at the mundane details, hotel bills, plane manifests, a ledger entry for massage, the more human the toll becomes. Those small notations often sit beside paragraphs where survivors describe coercion, pressure, and the long shadow of trauma. That juxtaposition is a kind of moral indictment in itself. Paperwork and pain side by side. There is a broader civic question embedded in that contrast. What responsibility do we, as a society, have to ensure that our institutions do not erect new space for similar conduct? The answer, many activists and legal experts argue, requires both transparency and structural reform. More rigorous oversight of prosecutorial discretion, better protections for victims, and less social deference when allegations touch the powerful. The Unsealed files have made the first condition, transparency, harder to resist. But there is one more thing to emphasize before we move deeper into the documents. The survivors. Their stories are not evidence in an abstract sense. They are accounts of disrupted lives. Civil settlements and court findings can close legal chapters, but they seldom erase psychological and material harm. The public attention that follows the unsealing of these pages can help validate survivors' experiences. It can also re-traumatize. That double edge imposes on journalists, producers, and viewers an obligation to cover the facts with rigor, but also to treat survivors with dignity. That means centering their experiences without fetishizing pain, and it means using the unsealed files to pursue accountability rather than spectacle. What remains to be excavated in the documents is where names become threads that can be followed to corroboration, and where names remain only names on a list. Over the next sections, we will retrace several of the most consequential lines in the files. We will map flight logs to sworn statements, examine references to photographs and alleged video, and interview legal experts about what civil filings do and do not allow prosecutors to do. We will also examine how the 2006 agreement functioned as a dampener on federal scrutiny for so long, and why its existence still questions the equity of the justice system. For now, the unsealed documents have performed a public service. They have moved many crucial allegations out of sealed courtrooms and private settlements and into a space where journalists, lawmakers, and the public can demand answers. The next challenge is to turn those pages into responsible investigation, to separate what is provable from what is alleged, to avoid the temptation of headline guilt, and to follow the evidence where it leads. The immediate revelation is simple and unsettling. Across thousands of pages, wealth and privilege appear not only as a context, but as instruments that widened the gulf between private harm and public accountability. The unsealed files offer a roadmap of connections. They do not by themselves convict everyone whose name appears. What they do, powerfully, is change the terms of the conversation. They force institutions and individuals to answer the question of whether money and access will continue to shape justice. Soon we will dig into specific documents and lines that matter most. The flight logs that list names and dates, the sworn statements that place survivors in specific houses and rooms, and the references to potentially compromising materials. We will examine what each kind of evidence can legally support, and we will listen to experts about how prosecutors might convert civil allegations into criminal cases, if the evidence supports that path. But before we move into that granular work, one final reality must be stated plainly. The unsealed files are both revelation and responsibility. They give the public access to material that was long hidden. That access obliges careful scrutiny, legal caution, and above all, respect for the people who stepped forward, often at great personal cost, to tell their stories under oath. The pages are shocking because they contain many things we feared might be true. The pages also demand that we do the hard work of transforming shock into methodical, careful investigation. The next chapter of this inquiry will begin that work by opening specific filings and tracing what they can and cannot support in a court of law. What follows is an attempt to trace the documents as evidence, to show precisely what the newly unsealed court files put on the table, what they imply, and where they leave us with more questions than answers. We begin with the plainest, most literal artifacts: passenger lists, ledgers, and sworn declarations, the pieces that can be verified on a page, and then move toward the harder human material: testimony about coercion, claims about recordings, and the institutional choices that allowed so much of this to remain hidden for so long. Flight logs first. They are the kind of evidence that makes headlines because they are concrete and discrete. A name, a date, a route. The files released from the civil litigation include flight manifests for Epstein's private aircraft, the planes that journalists quickly dubbed, in shorthand, the Lolita Express. These manifests show who traveled where and when, and they helped reporters and investigators establish patterns of movement: private jets connecting New York, Palm Beach, the Caribbean, and international locations. Flight logs are useful because they can place an individual at or near Epstein's world on a specific date. That placement matters, but the legal and evidentiary limits are equally clear. Being on a plane with Epstein does not, on its face, prove participation in any criminal act. Public reporting tied to the unsealed manifests identified a number of high-profile names that had been mentioned in previous accounts. Some individuals' representatives explained the context for those trips: work for a foundation, meetings with donors, business travel, and denied any improper conduct. Others have said little, and some have not faced criminal charges linked to the entries. The files make the entries visible to the public in a way that sealed records did not. Once a name appears on a manifest in the public record, reputational consequences follow immediately. That is an important social fact we must acknowledge while resisting the temptation to treat the presence of a name as proof of criminal behavior. Next, the sworn statements themselves, the documents that carry the legal weight of an oath. Civil litigation produces declarations made under penalty of perjury. Those statements are not idle gossip. They are formal assertions that a writer intends as truthful to the best of their knowledge. The files include dozens of such declarations from survivors who describe recruitment, grooming, and abuse in non-graphic terms. Virginia Giuffre's declarations, filed in court, state that she was recruited as a teenager and moved between residences where she was made to have sex with men she later named in litigation. Courtney Wild's sworn affidavit recounts years of consequences she attributes to being trafficked as a minor. Maria Farmer's statements describe early warnings she gave about Epstein's behavior in the 1990s. Those declarations are central because they provide a coherent narrative from multiple people with intersecting memories about specific locations, dates, and practices. From an evidentiary standpoint, the power of sworn testimony lies in its potential for corroboration. A survivor's account that places her in a particular house on a specific date becomes far more probative when travel manifests, photographs, receipts, or other independent documents place the same people and the same locations together. In other instances, testimony stands alone as the primary record, painful, credible, and legally important, but harder to convert into a criminal indictment without supporting material that meets the higher standard required in criminal court. The unsealed files also feature non-testimonial records that function as the kind of physical traces investigators prize: photographs, contact lists, and what have been referred to in reporting as message pads or ledgers. These materials vary in clarity. Contact lists, sometimes referred to in reporting as address books, show names and numbers. Ledgers and receipts can show payments, gifts, or expenses tied to travel and accommodation. Photographs, redacted in many of the unsealed pages, appear in some filings. The public record includes references to images, but not always to their provenance or content in a way that would permit independent authentication. And then there are the most incendiary references, mentions of recordings. Some sworn statements include lines that have been quoted widely. There are videos that exist, or language to that effect. Because such assertions occur under oath in court filings, they are, by definition, claims going into the judicial record. That is why the phrase carries particular news value. It feeds a theory that has circulated for years, that Epstein and his associates maintained a cache of compromising material, photographs, tapes, maybe more, to exercise leverage over powerful figures. If such material were authenticated and linked to coercion, it would be evidence of a different order. It would suggest an organized system of leverage that explains how some victims say they were silenced and why investigations stalled. But here again, the law and the public record force caution. The court filings assert that recordings existed. Investigators reportedly sought such material. Media reporting has described searches for storage units and devices. Yet to date, public authorities have not produced authenticated video for the public in a way that resolves the question definitively. Some material described in filings remains redacted or sealed. The mere existence of an allegation, even under oath, does not equate to an authenticated exhibit. The files push us toward the question. They do not, by themselves, supply the conclusive answer. There are pages in which small administrative details corrode any romanticized narrative of secrecy and instead reveal the ordinary infrastructure of alleged crimes. Hotel bills, entries for massage in a ledger, ferry receipts, and even simple calendar notations. Those banal records become moral indictments when paired with sworn testimony that explains context. Who was present? Who was paid? How a young person was introduced to a network of adults. The unsealed files glue together such fragments in ways that invite rigorous cross-examination. Dates on a manifest matched to a hotel folio, a ledger entry matched to a credit card charge, a photograph tied to an address where a survivor places an incident. High-profile names recur in these comparisons, and the files handle those names very differently depending on context. Certain figures appear on flight manifests. Others appear as contacts in lists. A few are specifically mentioned in survivor statements as having been introduced to them. Media organizations and legal analysts have been careful, as they must, to distinguish between these categories. Public statements responding to the filings vary. Firm denials, statements of limited context, and full acknowledgements of having been present in the same social sphere without any admission of wrongdoing. For each name the files thrust into the spotlight, the public record provides different levels of clarity. That variation is central to understanding both the investigative value of the unsealed material and its limits. The legal mechanics that produce these public pages deserve a short, plain explanation, because those mechanics explain why so much is newly visible now and why other material remains closed. The key mechanism was civil litigation, primarily defamation suits and related filings, which triggers discovery, the legal process by which parties obtain documents from one another. Discovery pulls together materials that prosecutors may never have produced publicly. In Epstein-related civil suits, plaintiffs sought documents, depositions, and records. Defense teams resisted by filing motions to seal, redact, and otherwise protect material. Judges then decide what remains sealed and what should be released. In the instances that produced the files currently in public view, judges ordered the unsealing of certain documents or permitted their release under the pressure of public interest and legal challenge. That is why the civil docket became a kind of window into what otherwise would have remained quiet. All of this must be seen against the backdrop of the 2006 agreement that many observers now see as pivotal. The non-prosecution agreement reached in Florida in 2006 resolved federal inquiries in a way that, in the view of subsequent prosecutors, curtailed potential federal indictments and gave Epstein an unusual degree of protection. One aspect of that deal, as later congressional reports and prosecutors described it, was the prospect of immunity and the effective sealing of victim cooperation from federal review for years. The consequence, according to the critics documented in the public record, was that leads that could have been pursued remained dormant. That long period of legal quiet helps explain why the civil filings years later were so important. They lifted the curtain on material that prosecutors had either not obtained or had not used in a way the public could see. Legal experts have emphasized the difference in standards between civil and criminal cases. A civil court requires proof by a preponderance of the evidence, more likely than not. A criminal trial requires proof beyond a reasonable doubt, a significantly higher threshold. That difference matters when we consider what these files can accomplish. Civil proceedings and public scrutiny can expose patterns and create pressure. Criminal prosecution requires a tighter chain of corroboration. In other words, the unsealed documents can supply journalists and prosecutors with leads, but converting those leads into prosecutable cases requires corroborative evidence and, in some instances, cooperative witnesses willing to testify despite the psychological cost. That legal reality intersects with practical obstacles. Evidence can deteriorate, witnesses' memories can fade, and in this case, key actors have died. Epstein's death in custody closed the door on his criminal trial and removed the defendant who might have been compelled to testify or to have his actions fully aired in a federal court. Maxwell's prosecution, conviction on charges connected to recruitment and transportation, provided an important public adjudication that buttressed survivors' accounts. But Epstein's absence from a public criminal adjudication means many of the questions can only be pursued through civil discovery, investigative reporting, or by prosecuting ancillary actors if the evidence supports it. The question of motive and method, why and how this allegedly occurred, frequently raises the subject of leverage. A number of statements in the public files allege that Epstein or associates documented encounters, kept records, and used those records to manipulate or to shield themselves. If that picture is accurate, it would explain the endurance of the network. People who feared exposure might have been less likely to cooperate with investigators, and institutions that might have acted were more likely to step back when powerful figures' reputations were potentially at risk. Again, here is the split between assertion and proof. The sworn lines that say recordings exist are not the same as produced, authenticated recordings presented in court or to investigators. They are, however, a clarion call for further forensic work. Searches of storage locations, subpoenas for electronic devices, and cross-referencing of physical media. Some of that work has been reported. Much of the forensic trail remains private or redacted in the public files. Institutional failure is a theme that runs through the documents in more than one register. On the law enforcement side, critics point to the narrowness of the investigation that produced the 2006 agreement and to the handling of evidence that might have led to a broader federal case. On the media side, the files and historical reporting document episodes where coverage was muted, names were withheld, or editors hesitated because of legal risk. On the social side, the unsealed records reveal instances where wealthy patrons and institutional elites circulated in the same networks that marginalized alleged victims. These patterns are not conclusive proof of a conspiracy among institutions. They are, however, part of a discernible pattern in which access, deference, and the financial power of one man and his associates shaped how allegations were handled. How do investigators and reporters move forward from the pages we now have? The work is painstaking. It starts with the basic cross-referencing any good investigation performs, matching a sworn statement that places a survivor at a Manhattan townhouse on a certain date to the flight manifest for a plane that lists passengers arriving on that date, linking a ledger entry to a bank record, corroborating a recollection with a hospitality receipt. It proceeds to the harder human work of persuading witnesses, sometimes reluctant, sometimes traumatized, to provide testimony or to confirm details. It then advances to forensic steps, seeking to authenticate images, subpoenaing storage media, and obtaining communications records that show contacts or instructions. The public files have already catalyzed such work. Journalists with long-term knowledge of Epstein's affairs have traced lines that prosecutors did not or could not pursue earlier. Those journalists, in many cases, have been able to publish corroborating evidence because civil discovery allowed access to material otherwise shielded. That is one reason the unsealing of documents is not purely symbolic. It materially changes what journalists and investigators can examine. At the same time, we must be clear-eyed about the limits. Some names in the files are social acquaintances, others are tied to charitable foundations that engaged with Epstein's money in public ways. Some entries are errors, coincidences, or the kinds of administrative notations that, without corroboration, tell little about misconduct. The legal system is designed to parse these differences. The public conversation often is not. Our obligation, as consumers of this material and as investigators in a democratic space, is to let the documents lead the inquiry while keeping attention on corroboration and on the human costs of reporting. Which leads to another vital point: the toll on survivors when records enter the public domain. For many people who disclosed abuse privately or in sealed settings, the decision to put their words in an unsealed document can be both a reclaiming of agency and a reopening of trauma. Coverage that emphasizes sensational names at the expense of survivor welfare risks replicating harm. Responsible reporting and responsible viewing require centering survivors' dignity, providing resources for support, and resisting the voyeuristic hunger that public curiosity sometimes fuels. Legal scholars and former prosecutors speaking about the files offer a pragmatic view of what could happen next. They say the files increase pressure on prosecutors to review cold leads and to use the newly public evidence as a starting point for renewed inquiries. They also note hurdles, statutes of limitation for certain offenses, the death of primary suspects, and the difficulty of locating corroborating physical evidence years after the fact. For some victims, civil remedies remain the primary path to recognition and recompense. For others, renewed criminal investigation could provide the accountability they seek. The unsealed files make both paths more feasible than they were when records were hidden. What about the most explosive public question? Who else will be held to account? The files name more than 150 people in a variety of contexts. That breadth is the heart of the shock the title promises. But breadth is not equivalent to guilt. For any individual named, the crucial inquiries are the same. What does the file show about their conduct? What corroboration exists? And what legal avenues remain to test those claims? Some names are already the subject of public scrutiny and legal action. Others are the subject of denials. The public will likely continue to put pressure on institutions, from law enforcement to private companies, to examine their records and to disclose what they know. There are also institutional reforms on the table that the files bring into sharper relief. Congressional and internal investigations can examine the conduct of prosecutors who negotiated the 2006 agreement, the role of federal agencies in pursuing leads, and the mechanisms that allowed records to remain sealed. Editorial offices and media organizations can examine their past choices and revise policies when reporting on allegations that involve powerful figures. Financial institutions can re-evaluate how they respond to suspicious activity tied to trafficking allegations. These are large, difficult reforms, but the release of documents can be the impetus for them. As this material circulates, we must also guard against two twin dangers: a rush to judgment based on public naming alone, and an acceptance of secrecy because the process is complex and slow. The right institutional response balances vigorous inquiry with legal restraint. It treats allegations seriously, protects the rights of the accused to due process, and centers the welfare of survivors who have already borne a disproportionate share of the cost. There are practical steps that can be taken immediately. Journalists and newsrooms can continue to annotate the documents, clearly distinguishing claims made under oath from corroborated evidence and from innocent appearances on manifests. Prosecutors can reopen leads where corroboration points to possible criminal liability. Legislators can scrutinize the choices that produce the 2006 deal and consider reforms to ensure victims' cooperation is preserved for future federal inquiries. And society, more broadly, can demand that institutions that interact with powerful donors, universities, cultural organizations, and philanthropies adopt clearer policies when allegations arise. We should close with 3 clear takeaways from the unsealed files as they stand in the public record. First, the scale of the allegations is substantial. Multiple survivors made parallel claims under oath about recruitment, grooming, and abuse in a set of private locations connected by travel logs and receipts. Those convergences are not trivial. Second, the presence of wealthy and influential individuals across the documents changes the public stakes. Whether those presences amount to criminal conduct in each case is a matter for further investigation. What is indisputable is that money and access allowed a private world to exist in which allegations could persist for years without full public accounting. Third, the unsealed files are a tool, not a verdict. They provide leads, context, and a basis for further inquiry. Converting their material into legal accountability requires careful corroboration, forensic work, and prosecutorial decisions. For survivors, the files provide acknowledgement and a public record. For the public, they require a responsible appetite for scrutiny rather than spectacle. Where does that leave the core questions the public now asks? Are there videos? Who else will be prosecuted? Will institutions change? The answer is, the documents increase the probability that investigators and prosecutors will pursue leads that were previously inaccessible, but they do not solve the evidentiary problems that have frustrated accountability in the past. The files make it harder for institutions to claim ignorance. They make it more politically and morally costly to ignore patterns of alleged abuse, but the jump from public naming to criminal culpability remains governed by the hard work of corroboration and legal standard. Finally, a note to viewers. The unsealed pages are available for scrutiny if you wish to read them yourself. They are complex, redacted in places, and often difficult to interpret without legal context. We have linked primary documents and the major source reporting in the description below, so you can verify what is public and draw your own conclusions with care. For survivors and those seeking help, please know there are resources. If you or someone you know has been affected by sexual abuse or trafficking, Organizations like the National Sexual Assault Hotline and local victim services can offer immediate support and confidential guidance. We have included links to vetted survivor resources in the description. This is not a closed story. The newly unsealed Epstein court documents have reframed the conversation about wealth, power, and accountability. They have placed evidence in public view that demands further investigation. They have validated the courage of survivors who spoke under oath, and they have exposed the institutional gaps that allowed these allegations to persist in secrecy. That combination is both a moral indictment and a call to action. If you have documents or information that you believe are relevant to these files, contact our newsroom using the address in the description. If you want to follow our in-depth document-by-document analysis, check our linked dossier for annotated filings and source material. We close where the unsealed pages leave us, with urgency and restraint, urgency to pursue corroboration, to reopen inquiries where evidence supports it, and to press institutions for answers. Restraint in how we interpret each name and entry, remembering the difference between allegation and adjudication. Above all, a call for compassion, to acknowledge survivors who came forward under oath, to preserve their dignity in reporting, and to convert shock into systematic scrutiny that might prevent repetition. The documents have changed the terms of the debate. Now it is up to investigators, prosecutors, institutions, and the public to follow the paper trail with rigor and with humanity.